very interesting webinar organized by CIADR. I am your moderator for today, Barrister Faisal Mahmood Honabil. I am an internationally accredited civil and commercial mediator for ADR ODR International as well. I am an associate counsel for CIADR and I'm the general secretary for YCIADR. Today's webinar will be on an interesting topic, which is the multi-party, multi-contract arbitration dispute. Multi-party and multi-contract arbitration in construction industry provides a very detailed review and a very detailed concentration of the multi-party arbitration in the international construction sector as a whole. It requires a highly practical approach and detailed interpretation in assessment of the arbitration of multi-party disputes, which facilitates the understanding and decision making by arbitrators, clients, and construction contracts. Land and construction has been one of the key assets or one of the key driving factors of the modern capitalism that we see, and it has been very important and thus leading to a number of disputes around the world. Therefore, this sort of arbitration has been very important over the years and certainly now more than ever. CIADR webinar series is making a path to create an actionable community and to ensure solution to combat the future economic crisis in the global community. Before I hand over the floor to our guest for today and introduce him, a little bit of an introduction about CIADR is necessary. CIADR stands for Center for International Alternative Dispute Resolution. It is the first and only online dispute resolution center in Bangladesh that provides very natural, reliable, and cost-efficient dispute resolution services in Bangladesh since 2018. CIADR is now renowned for its very cost-effective, fast-rating dispute resolution and very experienced independent arbitrators and mediators in South Asia. The CIADR and the new branding identity ODR institution envisions their persistent passion to spearhead a new era of ODR development and expansion, both for the CIADR and the global ODR ecosystem. CIADR aspires to be an uninterrupted provider of premium institutional aid as a tangible and independent venue for the conduct of domestic and international ADR and ODR proceedings. About our speaker today, we are extremely delighted to have Mr. Hugo Martins Ukoma, MCAIRB. Mr. Martins is an independent arbitrator and senior associate in the top-ranking dispute resolution practice in Nigeria's largest and leading full-service firm, Aluko and Uboide. He currently leads the firm's construction and engineering practice with focus on oil and gas, power, and infrastructure sectors. He holds an MSc in construction law and dispute resolution from the prestigious King's College London and has built specific expertise in construction law and arbitration. He has prior work experience with global construction law firm Vincent Masons London and leading set of constructions chambers, Heating Chambers London, as foreign qualified lawyers handling project claims and construction related projects. He has expertise in major standard forms of constructions and engineering contracts, including JTC, FIDIC, ICHEME, International Standard Version, bespoke forms involving founder-led EPC and EPCM. He advises clients on a range of issues on project developments and the resolution of dispute rising during projects, including dispute boards, adjudication, expert determination, and arbitration. He has acted as an independent arbitrator and arbitrator counsel in both domestic and international arbitration. Mr. Martins regularly presents in conferences and seminars. He is a founding member of the Society of Construction Law Nigeria, member of Construction Law Technical Subcommittee of Lagos Chamber of Commerce, International Arbitration Center, member of the Dispute Resolution Board Federation, United Kingdom, member of the Chartered Institute of Arbitrators UK Nigerian branch, and an executive director of the African Arbitration Academy. He has a wide range of representative case experience. He is currently providing legal advice to major ENP in relation to various prolongation claims arising from an EPC contract with an international contractor for the construction of Midwater Arch required for the development of certain OMLs in Nigeria. He's also currently providing legal services to a number of MNCs relating to ICC arbitrations and other disputes. Without further ado, if I may kindly hand over the floor to Mr. Martins. Mr. Martins, thank you very much for joining us today.
Thank you very much. Thank you very much for, it's an honor to be here and to be invited for this event. Today, I'd like to thank everyone. Today, I'll be speaking on multi-party, multi-contract arbitration disputes. If I could have the slides on.
I think the slides are on screen, Mr. Martin.
Yeah. Okay, thank you. I'm just trying to see how to move the slides to the next slide. Actually, great.
Right, no problem.
So today I'll be speaking on multi-party, multi-contract arbitration disputes. Clearly, if you've been involved in international construction disputes in the course of your practice, you will certainly at one point or the other have encountered situations around multi-party, multi-contract issues where a contractor, for instance, has a claim that has been made against him by the employer for probably delayed liquidated damages. And then the contractor in turn is looking to seek an indemnification, to be indemnified by the subcontractor. So these are typical situations you find in construction disputes. Traditionally, arbitration is perceived as a dispute between two parties in respect of a dispute arising from a single contract. This simplified version of arbitration, while it may hold true for many arbitration, is not always the case in construction disputes. Typically, multi-party and multi-contract may arise in three scenarios. The first scenario is where you have a multi-party dispute involving several parties to a single contract. So in this scenario, you have one contract, but you have multiple parties. A second scenario is where you have a multi-contract dispute involving two parties to the dispute, but several contracts, which are related to the subject matter of the dispute. The third scenario is the multi-party, multi-contract dispute type scenario, involving several parties to several contracts, all related to the subject of the disputes. What you typically find is that in construction disputes, you tend to find a scenario where there are multi-parties and multi-contracts in a situation where there is a dispute. And this is what you find most times in construction-related disputes. Could you kindly move to the next slides, please? Thank you very much. So, as you may well know, construction projects are procured in multiple ways. You may have a project procured through a build-only contract, where typically the employer will be providing the design instructions to the contractor, while the contractor is solely required to build the project. In other scenarios, you may have an EPC type arrangement where, for instance, in the EPC contract, you have the employer on the one hand, and then you have the EPC contractor who takes on the full responsibility for the design and the construction of the work. So as between the employer and the EPC contractor, the relationship is regulated by means of an EPC contract. However, in order to fulfill its responsibility, the EPC contractor may not have an in-house design team to design the project, and therefore he may need to engage an external design firm to assist with the design process. In such scenario, the relationship between the EPC contractor and the design consultant will be regulated by a consultant agreement. Usually in international projects, it's very unlikely that you find an EPC contractor carry out all aspects of the work because, of course, those projects are usually very complex and sophisticated. And also, it will be quite very expensive to find an EPC contractor who has the experience to perform all the facets of the work. So usually what you tend to find is that the EPC contractor will engage subcontractors, and in some cases, multiple subcontractors to perform aspects or different aspects of the work. In such scenario, there will be various subcontracts between the EPC contractor on the one hand and the subcontractor engaged to carry out an aspect of the work. Again, it doesn't end there. For the project to be performed, usually there will be needs to procure equipment and materials. And then the EPC contractor will need to engage a supplier directly who will provide the materials required to perform the work. And that relationship between the EPC contractor and the supplier will typically be regulated by a supply contract. So these various chain and level of interrelated relationship, all in relation to a specific project, may give rise to different types of disputes, which are quite very unique and which raises, of course, issues of multi-party, multi-contract issues. Next slide, please. So these are some of the scenarios, and these scenarios are not intended to be exhaustive, but these scenarios effectively gives you a sense of the kind of disputes we're looking at here. If you take an EPC contract and you have an employer's claim for defects, employer may wish to advance claims against the EPC contractors for defects in the work under the EPC contract. The EPC contractor believes that the defect is due to the fault of the subcontractor and may wish to seek indemnification from the subcontractor. The question then is, how can the subcontractor be made a party to the reference between the employer and the EPC contractor, knowing full well that the subcontractor is not privy to the arbitration agreement between the employer and the EPC contractor? While multi-party arbitration in this context might be favorable to the EPC contractor, the employer may, for tactical reasons, may not give consent to a multi-party arbitration process, apparently. On the one hand, the employer may view multi-party arbitration as advantageous if, for instance, collateral warranties were provided by the subcontractor and the employer perceives that the main contractor is likely to go bust. In such situation, he would want to have a multi-party arbitration process where he could bring in the subcontractor into the arbitration in order to be indemnified for its loss directly from the subcontractor. Next slide. A second scenario may arise where you have claims for liquidated damages, delay, disruption, and prolongation costs. So in this scenario, you have a subcontractor who might want to bring a delay and prolongation cost claims against the EPC contractor. The EPC contractor, who in turn may seek indemnification against the employer for a related claim. The question then is, how can the employer be made a party to the reference between the subcontractor and the EPC contractor? The employer may also bring a claim for liquidated damages against the EPC contractor, which the EPC contractor may seek to pass down the chain to the subcontractor. Again, how can the EPC contractor make the subcontractor a party to the arbitration between the EPC contractor and the employer? Next slide. Another type of procurement arrangement you may have in a construction arrangement is an is an EPCM contract type arrangement, which effectively means engineering, procurement, and consultant management contracts. This is where typically you have the EPCM you have the employer who engages the EPCM contractor to carry out the design and manage the procurement of the project. And in such situation, such an engagement will usually be through an EPCM contract. However, the EPCM contractor may not have the in-house capacity to carry on the design. So in such situation, the EPCM contractor may have to engage an external design consultant who will carry out the design works. Such bilateral arrangements between the EPCM contractor and the design consultant may be by way of a design subcontract. In turn, the employer would then have to engage the works contractors directly, who would actually perform the works themselves. In such situation, the employer would have to enter various or one construction contract with the various construction contractors that have been engaged for the project. Again, there will certainly be a requirement to provide materials and equipment that will be required for the work. Apparently, the employer would then have to engage directly suppliers who would provide these materials through several supply contracts entered between the employer and the supplier. The question then is what are the possible types of, how would you have a multi-party dispute type scenario emanating from this type of contract arrangement? Next slide. So taking a claim for defect as an example, you have an employer who seeks to bring an action for defects under an EPCM contract type arrangement, which may be partly due to a design error and workmanship. He may bring an action against the contractor under the construction contract, but also requires the EPCM contractor to be a party to the arbitration, given that the design responsibility for the project was undertaken by the EPCM contractor. How can the EPCM contractor be made a party to the arbitration proceedings, given that it is not privy to the arbitration agreement between the employer on the one hand and the works contractor on the other hand? Next slide, please. Another scenario you may find is, again, claims for delay and prolongation costs. The contractor may seek to advance a delay and prolongation cost claims against the employer due to late delivery of the design instruction. The employer in turn will be seeking indemnification against the EPCM contractor, and as such would want the EPCM contractor to be part of the arbitration process between it and the works contractor. How can this be achieved? While multi-party arbitration would obviously be desirable by the employer, that may not necessarily be the case for the contractor. And of course, in such scenario, an ad hoc arbitration agreement may be impossible, because where, for instance, the employer wished the parties to enter into an ad hoc arbitration agreement in order to bring in the contractor into such dispute, the contractor may not be willing to do so. So what's the benefits of a multi-party arbitration process? So, I mean, there are various scenarios. So typically what would happen is, because of these types of scenarios I mentioned, you may have a situation where parallel arbitrations are running. So you have in a claim for, potentially a claim for LDs and a claim for delays and prolongation costs. You may have a scenario where an arbitration between the contractor and the employer is running, and then you have another situation where an arbitration between the contractor and the subcontractor is also on foot. But of course, this is not desirable. What would make perfect sense is to have the arbitration, all parties be made a party to a single arbitration process, where the various issues of laws and facts will be decided in that arbitration process. Apparently, this is required in order to avoid the risk of inconsistent findings. A contractor, for instance, would not want to find itself in a situation where an employer has successfully made out a claim against it for liquidated damages under the main contract, but the main contractor is unable to pass on that liability or that liability to the subcontractor under another arbitration that is commenced under the subcontract. Obviously, this would, because of the risk of this, obviously raises risk of inconsistent findings. There's also the issue of cost and time. Having multiple arbitration running parallel will obviously be costly and time consuming. Next slide. The challenges. There are various challenges as I've mentioned. For instance, how can a party be forced into an arbitration with a party not privy to the arbitration agreement? How will the tribunal be appointed? This is also a very serious problem, because the hallmark of arbitration is that each party must be given an equal opportunity. The process, there must be an equality. Each party must effectively be given an equal opportunity. This is very clear when it has to do with appointing the tribunal. So typically, what you tend to find in the traditional system is that where you have a panel, a three-party arbitral tribunal, the claimant will typically nominate an arbitrator, and then the respondent nominates another arbitrator, and both party nominated arbitrators then appoint the chair. But what you tend to find is where you have a multi-arbitration, where you have a multi-party type scenario, where, for instance, especially as demonstrated in the .co case, where the claimant had nominated an arbitrator, and the respondents, who in this case there were two respondents, were unable to agree to a single arbitrator. And then because they were unable to agree, the default appointing institution, which in this particular case was the ICC, then nominated an arbitrator on behalf of the respondent. Eventually, when an award was made, the respondent challenged the award. The court held, in this case, the Court de Cassation held that the appointment process breached the principle of equality of treatment because the respondent did not have the same opportunity as the claimant to influence the decision of the ICC when composing the tribunal. In effect, this was against French public policy, and as a result, the award was invalidated. So this is clearly one of the issues you find in these types of scenarios. There's also the problem of how can the party not privy to the arbitration agreement be bound to the tribunal's award? How do you deal with issues of confidentiality? Because clearly, if you are bringing another party into the arbitral proceedings, confidential information may have to be made available. So how is this dealt with? Next slide. Obviously, the solution here is to have a multi-party arbitration process where all the issues of facts and law are decided as against all the parties to the dispute. This can clearly be achieved through consolidation or the joinder of the parties to the reference. So if there is a joinder of the parties to the reference, to the existing reference, that all the issues will be heard before a single arbitrator, or it may well be that there are concurrent hearings, but before a single arbitral tribunal. But again, it is easier said than done in a construction type dispute scenario. The question is, how do you then achieve consolidation? How do you achieve joinder of the parties? One way to do it is to have an ad hoc agreement, and that would just have been a perfect scenario where all the parties discovering the problem that has arisen then agree to have all the issues resolved before a single arbitral tribunal. So in such scenario, the parties would have to would have to settle a written agreement for multi-party arbitration after a dispute has arisen. This is, however, easier said than done, because once a dispute has arisen, the likelihood that parties will agree to an ad hoc agreement is very slim. Next slide. Another possible solution is court intervention. The consolidation of the references is imposed by the court without the consent of the parties. This approach has been adopted by a few jurisdictions. For example, in the arbitration law of Netherlands, this has been adopted. Also, the state of California, which is a model law country, amended its provision to include court-enforced consolidation of arbitral references. The construction industry, obviously, was the driving force behind this approach. Until date, remains the principal users of this law. The approach is generally rejected because it negates the principle of party autonomy. Party autonomy being the hallmark of arbitration. The risk is that where you have a court-enforced arbitration process, this obviously breaches party autonomy. It also negates the principle of minimal court intervention in arbitral proceedings, because in such scenario, you have to be going to the court to enforce the arbitration. Another significant problem with this option is that it leaves a potential ground for refusing the enforcement of the arbitral award under the New York Convention. That is under Article 5 sub 1 sub D of the New York Convention. Now, Article 5 sub 1D of the New York Convention provides that the recognition and enforcement of the award may be refused if the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. So clearly, parties run the risk of having the award refused recognition. Next slide. How has this problem been resolved under the arbitration rules? Is the arbitration rules actually the solution to these issues? The reference to certain set of arbitration rules constitutes the parties' consent to the conduct of arbitration under these rules, including in respect of multi-party arbitration issues. It is the legitimate expectation of the parties that arbitration rules provide a balanced and flexible mechanism for the review of disputes which does not cause prejudice to any parties. Next slide. So let us consider some of the rules that we know of today. The first, the ICC rules, 2017. The ICC rules provides that a party may request that an additional party be joined to the arbitration by submitting a request for joinder to the ICC Secretariat. If the request for joinder is submitted after any of the arbitrator has been confirmed or appointed, the rules provide that no additional party may be joined unless all the parties, including the additional party, agree. Again, the ICC takes us back to consent, saying that there is a requirement for consent by the parties in order to have joinder. If the request for joinder is submitted prior to any of the arbitrator being confirmed or appointed, the question of the propriety or otherwise of determining the claims in a single arbitration will be determined by the tribunal, unless the Secretary General refers the matter to the ICC court. Next slide. If such question arises in a construction dispute, it is very unlikely that the matters will be referred to the ICC court, as the multi-party, multi-contract nature of the dispute creates doubt as to the existence of a prima facie basis for asserting an ICC arbitral jurisdiction over the multiple claims. Its multi-party, multi-contractual nature presupposes the existence of several parallel arbitration clauses binding parties which are not identical. The ICC court will allow the multi-arbitration to proceed in multi-contract disputes where two conditions are fulfilled. First, the arbitration agreements are compatible. Secondly, all parties involved agree that the claims can be in a single arbitration. So the takeout point from the ICC rules on joinder, and as we're going to see in relation to consolidation, is that before any of these can be done, it requires the parties to give their consent. So even though the ICC provides for a consolidation procedure, it provides that the ICC court may, at the request of a party, consolidate two or more arbitrations pending under the rules into a single arbitration where the parties have agreed to consolidation. Let us look at the LCIA rules. Next slide, please. The LCIA rules provides for joinder. However, unlike the ICC, the LCIA adopts quite a slightly different approach. It provides that it gives the tribunal the power to join third parties to the arbitration at the request of a party, provided the third party and the applicant party consent in writing. This provision has been subject to criticism since it allows a third party to join the arbitral proceedings, even in the absence of agreement by one of the parties. How viable is this? Next slide. The LCI rules require, on consolidation, require all parties to the arbitration sought to be consolidated to agree to such consolidation in writing. If there is no such agreement, the pending dispute can be consolidated only if there is a single arbitration agreement between all the parties and or a compatible arbitration agreement between the same parties. None of these requirements will be satisfied in a multi-contract construction dispute, which of course involves multi-party, multi-contract type scenario. Next slide. So the point to note in relation to the LCIA rules, obviously, is that it allows for joinder, it allows for consolidation. In relation to joinder, there must be an agreement between the party seeking joinder and the party seeking to be joined under the reference. But the key problem with that is that how practical is that, especially where you have a situation where the party to the reference is not required under the rules to give his consent. This may raise issues regarding the jurisdiction of the LCIA tribunal to actually determine such disputes. The UNCITRAL rules allow for joinder of a third party to an arbitration proceedings only where such third party is a party to the arbitration agreement. If the joinder would result in prejudice to any of the parties, the tribunal has the power to refuse the request for joinder. This provision clearly is unsuited for multi-contract construction disputes and likely to apply only where there is an umbrella arbitration agreement to which all the parties are signatory. Next slide. So what we find from looking at the rules is that the rules, in most cases, take you back to the parties and say that the parties need to give their consent in order to have joinder or in order to have a multi-party arbitration process through consolidation. So how can this be dealt with? There is a possible option of the contractual solution. This is where parties may draft identical arbitration provision for multi-party arbitration disputes. The arbitration clause should be clear in order to avoid confusion or disagreement between the parties. So what this effectively means is that prior to disputes, the parties at the time of entering into their contract must have envisaged possible dispute type scenarios that would arrange from the project structure. And in such situation, the party would then have to draft multi-party arbitration clauses in their contract in order to ensure that in any given scenario, the parties would be at liberty, the tribunal would be at liberty to join any of the parties whose presence is required for a proper determination of the dispute. Or you may have a scenario where arbitration under different arbitration clauses could be consolidated under a single reference. It's interesting to see how the FIDIC has dealt with this type of scenario, the FIDIC approach. In 2011, the FIDIC published the FIDIC conditions of subcontract for construction, which was to be used in conjunction with the FIDIC conditions of contract for FIDIC conditions of contract for construction. That's popularly what is called the Red Book. The FIDIC conditions of contract and subcontract include compatible dispute resolution clauses only as it relates to disputes referred to dispute referred to the DAB. The procedure, the DAB being the Dispute Adjudication Board. The procedures under the claims process, that's the engineer's determination under the main contract and the contractor's determination under the subcontract and arbitration under both contracts remain parallel. Next slide. Clause 20 of the FIDIC condition of subcontract provides that if the contractor Clause 20 of the FIDIC condition of subcontract basically provides for the dispute resolution clause. It provides that if the subcontractor has a claim against the contractor will make a fair determination of the claim. If the subcontractor is dissatisfied with the determination, the dispute will be referred to the DAB under the subcontract. The contractor must then decide whether the dispute is a related or an unrelated dispute. If it's an unrelated dispute, then obviously there is no problem. The dispute will proceed to the DAB under the subcontract and to arbitration under the subcontract. If, for instance, a notice of dissatisfaction is given against the decision of the DAB. But if it's a related dispute, if it is related to the dispute under the main contract, that's obviously where there are issues. The parties shall defer. The subclause provides that the parties shall defer any referral of the dispute to the subcontract DAB for a period not less than 112 days. And the contractor would refer the dispute to the DAB under the main contract. So apparently what happens here is that you have a dispute, the subcontractor has a dispute, the subcontractor takes the dispute to the DAB. The clause provides that the main contractor has the main contractor is to assess it and make a decision whether or not the dispute in question before the DAB is a related or an unrelated dispute. If it's an unrelated dispute, then the dispute will proceed before the subcontract DAB and then possibly go to arbitration. However, if the main contractor decides that that is a related, the subcontract dispute relates to a dispute under the main contract, then what it says is that the contractor would refer the dispute to the DAB under the main contract itself. Next slide. Once the main contract DAB issues its decision, each party then has different options. So clearly, the main contractor has referred the dispute to the main contract DAB to make a decision. The main contract DAB then makes a decision. The question then is, what options do the parties have? The contractor, if for instance the contractor, once the decision has been made, the contractor, for instance, is entitled to refer the subcontract dispute to the subcontract DAB, while the subcontractor has the option of referring the subcontract dispute to the subcontract DAB or straight on to arbitration itself. So this is perfectly sensible because the subcontractor is not bound by the decision that has been made by the DAB under the main contract. Obviously, the contractor then takes that decision and then submits it to the subcontract DAB in order to make a case against the subcontractor, obviously. And then the subcontractor then has an option of either referring the subcontract dispute to the subcontract DAB or going straight off to arbitration. However, if the two dispute proceeds to arbitration, what the FIDIC forms provide is that the dispute under the main contract and under the subcontract, they will not be consolidated or harmonized, even if they are related. So apparently you find that that harmonized position is only experienced as it relates to the DAB process, the Dispute Adjudication Board process under the FIDIC contract. But if the parties have to move on beyond the DAB to arbitration, what it provides is that those arbitration will run parallel. The arbitration between the employer and the contractor will run parallel with the arbitration between the main contractor and the subcontractor. Obviously, the question you want to ask is the FIDIC approach the best approach? Is it not the case that the essence of having a multi-party arbitration arrangement is to be able to ensure time and cost efficiency, and also to prevent potential scenarios where you have conflicting decisions, where you have a scenario where ultimately the arbitration process have to run in parallel? Then of course it takes us back to the problem that we've always been talking about under a multi-party, multi-contract dispute type scenario, which is the risk of inconsistent decisions, and of course increased costs and increased time in the entire arbitration process. So what lessons can we draw from these various scenarios? The first, of course, is that court-enforced multi-party arbitration is not the solution, as most jurisdictions do not adopt this approach. Notwithstanding the fact that the national laws in some jurisdictions provide for court-enforced multi-party arbitration must be taken into account in choosing the seat of the arbitration to avoid a scenario where a party is being forced to participate in an arbitration against its will, or permit the participation of non-contractual parties in the arbitration proceedings. The arbitration rules considered are unsuited for multi-party contract construction disputes, as they effectively require the consent of all the parties before the dispute can be heard in a single arbitration proceedings. Even where the LCI rules allow for joinder of a third party in the absence of agreement of all the parties, tribunals constituted under the LCI rules will usually refrain from admitting joinder or consolidation in the absence of explicit parties' consent. This is because of the risk of setting aside or non-recognition or non-enforcement of the procedural irregularities. Next slide. The likelihood that the parties will agree to an ad hoc multi-party arbitration, the likelihood that the parties will agree to an ad hoc multi-party arbitration agreement after the dispute has crystallized is obviously quite remote, as a party may object to such proceedings for tactical reasons. It would then therefore appear that the best solution is for parties to make provision for multi-party arbitration in their arbitration agreement. In drafting such clauses, it is important that parties have a clear idea of how they would wish future disputes to be handled. Setting up multi-party arbitration requires careful drafting and specialist legal advice. If parties find themselves in a situation where a dispute has arisen under construction contracts, which do not contain a specific multi-party friendly arbitration clause, they should carefully consider their options, taking into account the need to ensure that the dispute is handled in a cost-effective and timely manner.
Well,
Thank you very much.
thank you so very much, Mr. Martins. I mean, it has been a rather crisp, pertinent, and can you have the views on the entire screen? I'll request the technical team to take away the slides and have the views in the screen kindly. Right. As I was saying, Mr. Martins, thank you very much. It was a rather crisp, pertinent description of a part of an arbitration which is considerably technical and unfortunately has become an invariable norm of modern day arbitration, considering the prevalence of construction and multi-party in almost in every modern day commercial contract, be it construction or anything else. We're doing very good with time. We certainly have a number of questions from our guests, and certainly I would like to personally ask you a number of questions. I'd like to thank you for considering the rules in details, considering the fact that at the end, these are the protective layers that gives us certain solutions in regards to the practical and legal difficulties that we face in regards to a multi-party, multi-party construction agreement in particular. Now, if I may go back to, if I may ask you a bit basic questions for our audience, considering the fact that it is certainly a very critical aspect of arbitration and requires an advanced knowledge of arbitration as well. Now, if I may go back with FIDIC, the FIDIC approach. Now, I understand, and I certainly you have vividly mentioned clause 20 of FIDIC. Other clauses such as clause 4 express requirements that the contractor shall be responsible to the employer for the act and defaults of any subcontractors or its agents or employees. Now, my question to you is that such wide and strict liability under FIDIC is not the case under some national laws. For example, English law provides that a contractor is not necessarily responsible for any design carried out by a nominated subcontractor, or whether the subcontractor has complied with the performance specifications of the goods and materials. Now, my question to you is that for those countries or for those laws, how do you actually tackle these problems of the required consent of all the parties?
Yeah, I mean, it's a very valid question. As you know, the hallmark of arbitration basically is party autonomy, and clearly, what it means is that it requires the consent of the parties. Apparently, in a practical scenario, and in most arbitrations, in most disputes that I tend to see in practice, is that where there is such a dispute and you have a situation where a multi-party, an ad hoc agreement is required, it is usually extremely difficult to find that all the parties will be willing to give their consent. Obviously, the party to whom it is beneficial to have a multi-party arbitration process would be willing to consent to an ad hoc agreement effectively. But for tactical reason, the other parties may not, for instance, want to give their consent. So for instance, and there are several reasons why. It may be, for instance, the party may not want to have its confidential information under the contract itself disclosed to a non-party to the contract. It may also be that for an employer, for instance, would want to just have its remedy against the main contractor directly, rather than having the subcontractor brought into the dispute. Because where you have the subcontractor brought into the dispute, that may then prolong the arbitration process and obviously just complicate things. So an employer may want to have a simple, straightforward situation where he's able to recover its losses directly against the main contract under the main contractor under the main contract itself. So these are typically what you tend to find. So in reality, finding a situation where all the parties are willing to give their consent is usually very rare. It's not impossible. You may have a situation where, for strategic reasons, party may feel that, well, in order to ensure cost efficiency, let us have a multi-party, an ad hoc agreement to have a multi-party arbitration amongst all the parties. So usually cost typically could be a serious consideration that may drive such an agreement. But that's usually in extreme cases. In most cases, you tend to find that it is just it is just the case where the parties are just not willing to enter into an ad hoc agreement, and that's why it is often advisable that at the time of the contract negotiations between the parties, and during the contract negotiation process, the parties think carefully about the dispute resolution clause. The parties envisage, for instance, an employer who looks at the nature of the project and envisages that it may well be in its interest to have a clause that allows for consolidation and joinder, because there's a strong likelihood that when disputes arise, he may be in a position where he would want a multi-party arbitration process in order to recover remedies directly against, in order to have other parties. So for instance, the design consultant as part of the arbitration process in a claim for defect, for instance. In such situation, it is often often advisable to, at the point of drafting the contract, to envisage all these possibilities and include appropriate and draft an appropriate clause that can deal with all these eventualities.
Right. Thank you. Thank you so very much. I will actually go back to this point in a while, but first I actually wanted to ask you another interesting thing. Often we see in the non-construction arbitrations that tribunal ascertain implied consent for multi-party arbitration on the basis of different legal theories for non-signatories, such as agency's assignment, third-party beneficiary, incorporation by reference, alter ego, or equitable or arbitral estoppel. We certainly do not see similar notion or similar construction in agreements as such, construction agreements or multi-party construction agreements. Do you think a rather loose or a rather wide interpretation of these legal notions that we often see in non-construction agreements will be to some extent of benefit in this regard for this problem that we're talking about?
I think it would be problematic to have such a very wide interpretation, where, to make it a bit more practical, where, for instance, you have a scenario where a contractor will be considered as a main contractor, for instance, will be considered as an agent, or so I mean, for instance, where you find that the main contractor will be considered as a principal for the subcontractor. I think that would be extreme, because you find a situation where, I mean, again, it depends on the applicable law in question. But typically, what you tend to find in most jurisdiction, English common law jurisdiction, for instance, is that you have privity of contract between parties. So you have the employer on the one hand and the contractor who enter into and the main contractor who enter into a construction contract. The principles of privity of contract apply between both parties. And then on the other hand, you then have the main contractor and then the subcontractor who enter into a subcontract agreement. And then the principles of privity of contract apply between both parties. The likelihood that you will find a tribunal who would construe the contractual arrangement between the parties, for instance, where a main contractor would, under such an interpretation, would be considered as a principal of a subcontractor who would be the agent. It's very unlikely, and that's why usually these legal theories that have often been applied to other types of disputes would typically not apply in a construction type arrangement where you have this type of arrangement I talked about, a main contractor arrangement and then a subcontractor arrangement.
Thank you. Thank you very much. I'll go back to this arrangement related consideration as well. But now that you have mentioned the jurisdiction that really allows to some extent some sort of direct remedies, if I may follow you up with one question in that regard, that we see that English law in particular provides direct possibility of direct claims or remedies between the employers and the subcontractor through, as you have gracefully mentioned, direct collateral agreement, or there has been cases that established implied warranty between the employer and the subcontractor, or the very widely talked about the establishment of duty of care established by representation. My question to you is that do you think these jurisdictions that allows a number of avenues for direct claims between the employer and the subcontractor, in those jurisdictions it's rather easy to have an arbitration of this sort in comparison with other jurisdictions that does not have these direct claims?
I mean, I think that's a very good question. Yes, apparently, usually the relationship between the parties will be regulated by contract. But typically, you find when you have a collateral warranty type arrangement, where, for instance, the subcontractor is giving a warranty directly to the employer, you typically find typically find a dispute resolution clause type scenario in such a situation. So it would then turn on if, for instance, you have compatible dispute resolution clauses in the contract. So if, for instance, in the collateral warranty, there is a compatible dispute resolution clause with that of the main contract itself, then it will be possible for you to have a multi-party type arrangement in such scenario. But other than such an instance where you have compatible dispute resolution clauses, then that may pose a different type of challenge entirely.
Right. Thank you very much. Now, if I may kindly move on to the mechanisms that we currently have. We have already talked about the collateral agreement of some sort between the employer and the contractor. Now, if I may kindly move on to the multi-party arbitration clauses. Now, I'd like to ask you this from a practical perspective, that we often see that parties may draft arbitration agreements that include all the relevant parties, either in form of one umbrella arbitration agreement or by drafting several identical arbitration clauses providing for multi-party proceedings under certain circumstances. I mean, we see that umbrella arbitration agreements are not typically used in construction contracts, but identical arbitration clauses providing for multi-party proceedings are certainly not uncommon. My question is that how important is clarity in drafting and precise construction in regards to avoiding any confusion or disagreements in these sort of clauses, which of course might help us avoiding any delay or any other delaying tactic by any of the parties in any of the arbitrations, which is a very important consideration as well, I suppose.
That's a very good question. Clarity is obviously in drafting those clauses, particular attention must be paid to drafting those clauses, because the objective is to achieve clarity as much as possible. If the dispute resolution clauses are clear, and it makes and it's so clear from those clauses that that the references can be harmonized, or it can be consolidated with the other reference. Then it saves parties the cost of looking to enforce the dispute resolution clause. So I mean, a typical example is the case which I mentioned earlier on. That's the City and General versus AYH case, where the main contractor agreed to carry out works of refurbishment and rebuilding. And and so you had a situation where there was a main contractor and there was a subcontractor on the other hand. Now the contract between the employer and the subcontractor the contract between the employer and the main contractor included an arbitration clause providing that any disputes will be referred to arbitration by a single arbitrator, and that if the dispute raised issues that are the same as or connected with issues raised in related disputes between either parties and a third person already referred to arbitration, the parties agreed that the disputes under the deed would be referred to the arbitrator appointed to determine the related disputes. So apparently the wording wasn't sufficiently clear, and then there was a question about whether this was a related dispute or not. The parties then had to go to court for the purposes of enforcing the arbitration clause. The court held that although there was no clarity, but the court then took the position that you needed, that there was a need to determine what was the purpose of that provision, and that the purpose of that provision was to achieve multi-party arbitration process in order to save time and cost. And for that reason, the court then enforced it. So you find that because of the ambiguity or the lack of clarity in the clause itself, the parties had to seek an interpretation of that clause and seek the aid of the court in enforcing it. But if the clause is clear, then it will be clear to the parties that it's possible to consolidate the reference to have a multi-party arbitration proceedings. So clarity, like you rightly said, is absolutely key in order to save time and save costs and prevent a situation where parties need to seek an interpretation of the provision.
Thank you so very much. I hope you're okay with the questions, considering the fact that has been a really educational seminar or a webinar for all of our viewers. I'm certainly sure about that, and it has been very, very aware, educational, and enlightening for me as well, considering the technicality and considering the details that you have focused as far as FIDIC or any other laws are in concern. So thank you very much for that. If I may kindly go back to FIDIC clause 20 that you have mentioned, and you have talked about the problems that the problems that saving time or cost or avoiding inconsistent result that we see. If you would kindly tell us something about the alternate provisions apart from clause number 2 that FIDIC provides, the alternative dispute resolution processes, for example, amended clause 20 and everything. My question to you on this is that FIDIC, to some extent, on the face of it, looks very good, looks amazing as far as its rules and regulations are concerned. However, we certainly see certain problems of this, as you have mentioned. How critical it is in terms of avoiding the delay, or in terms of avoiding any delaying tactic or cost, considering the fact that in these sort of multi-contract construction dispute, cost and time is often a very important consideration for all the parties.
Yes, yes. I mean, if I got your question correctly, I mean, obviously time is obviously important, and especially, of course, especially in construction contracts, where time is obviously of essence, and where the contractor typically has to deliver the project within a specific time frame. What you want to avoid is a scenario where the parties run into disputes, and because of the dispute, the project is derailed. So it is because of this that the FIDIC contract has devised certain mechanism to be able to address these types of scenarios. So for instance, the FIDIC contract provides, a typical FIDIC contract provides a claims procedure which effectively requires the engineer to make a determination in relation to any claim that has arisen between the parties during the course of the project itself. The reason for that is to ensure that while the project is ongoing, there can be a quick determination by the engineer who can make a determination one way or the other. But of course, because under the FIDIC contract, the engineer acts as an agent for the employer, the contract then provides for a dispute adjudication board. And of course, the recently released FIDIC contract forms, which is the 2017 contract, then provides, in this particular situation, provide for a dispute adjudication, a DAB effectively, which is more like a standing DAB procedure. But I mean, the rationale behind all this effectively is to have a situation where if the contractor is dissatisfied with the decision of the engineer, he can then submit that determination, or that, he can then submit he can then effectively take that dispute to the DAB for the DAB to make a determination one way or the other in relation to the dispute itself. The essence of this mechanism effectively is to put an effective mechanism in place to ensure that while the project is running and the contractor continues to carry out his obligation, any dispute arising in relation to the project is being resolved in real time, quickly, and the project is ongoing effectively.
Thank you very much. Certainly, we have discussed in range as to the laws in question, which has been very educational for our viewers. If I may go back to a little bit basic questions now that we have considered as to the existence of collateral agreement or separate arbitration clauses and everything else all together, and the relevant laws as well. If I may kindly ask you that, according to you, while drafting these agreements and before even going into any arbitration process, at the very beginning, while going into these agreements or these understanding between the parties, what is the safest and the most cost-effective way to ensure that if need be, we can actually get into a multi-party arbitration? Is it the existence of separate collateral contract or an umbrella arbitration clause, or a proper contract or a proper contract between all the parties in total, all the subcontract and the employers? What is the safest and the most cost-effective methods according to you, practically speaking?
Well, I mean, I think the most efficient manner would be to have a multi-party arbitration clause, a multi-party arbitration clause in the contract itself, amongst all the parties. But as discussed previously, because of the nature of the relationship, the nature of the types of relationship that is created in a construction project, it's not possible to have a multi-party arbitration clause in a contract, in a construction contract, because you have different layers of contracts creating different layers of relationship. So the next best case scenario is to then have compatible arbitration clauses in these different layers of contracts that have been created by the various relationships. So you have, for instance, an employer who enters into a consultant agreement with the design firm, and you have an employer who enters into a contract with the main contractor. So effectively, what then happens is that they have to be a compatible arbitration agreement in these several layers of contractual relationship that have been created with these several parties. The effect of that is that when a dispute arises, and then there is a need to have a multi-party arbitration process, because there is because they are compatible arbitration clauses, then it will be easy for the tribunal to consolidate the reference, or to join a non-party to the arbitration process itself. So I think there are two guiding principles which I will touch on. The first is have a compatible arbitration clause. The second is draft the contract in such a way that the tribunal would effectively have the power to be able to make a joinder or a consolidation, as the case may be. So the trick is to ensure that from the contract, it's to ensure that the arbitration clauses themselves give the tribunal the power to be able to make these types of determination.
Thank you. Thank you very much. On this note, I'd like to go back to the laws in regards to joinder and consolidation, as you have amazingly mentioned throughout your presentation in the slides as well. Consolidation, we see that a number of jurisdictions certainly often do not allow consolidation, and however, Netherlands does. And we have talked about joinders to a large extent as well. How important in regards, as far as arbitration rules allowing for third-party claims are concerned, how important or how feasible is provisions or claims based on multiple contracts, apart from joinder or consolidation, as we have talked about?
I'm sorry, I didn't get the question clearly. How important is what?
My question is that often we see that major arbitration jurisdictions do not include provisions regarding consolidation of multiple arbitrations. We see that there is a provision of this sort in article of Netherlands Arbitration Act.
Mm-hmm.
We have talked about consolidation and joinders in detail as well. I wanted to know that apart from joinder or consolidation, as far as arbitration rules allowing for third-party claims are concerned, how beneficial are claims based on multiple contracts?
So if I understand you correctly,
Yes.
So potentially you're talking about national laws that potentially
allows claim based on multiple contracts. Yes,
exactly, national laws that allows claims based on multiple contracts, and that's where you have a scenario where the court would then have to enforce multiple contracts, multi-party arbitration basically amongst the parties. I mean, yes, that we see that in a number of jurisdictions, and of course you've mentioned a couple. The challenge with such process is that you have a situation where the court would effectively be compelling the parties to arbitrate, and the challenge with that is that arbitration traditionally, as it is envisaged, as it is conceived, the underlying principle behind arbitration is party autonomy, in which case arbitration must be based on the voluntary consent of the parties. Where you have a scenario where the party begin to enforce arbitration, compel parties to basically arbitrate against their will, then the court would effect that party autonomy. The principle of party autonomy that autonomy itself is effectively being taken away from the parties, and that of course is a challenge. And that of course is a challenge. It may become very relevant when it has to do with enforcing such award. Or so, taking the New York Convention for example, the New York Convention, one of the grounds for refusing enforcement under the New York Convention is where the composition of the arbitral tribunal or the arbitral procedure itself was not in accordance with the agreement of the parties. So where that autonomy, where the ability for parties to give their consent towards an arbitral process is being taken away from them, there is a risk that any award that is being made as a result of a court-enforced multi-party arbitration process may be set aside or refused recognition under the New York Convention. So that obviously is a big challenge.
Thank you. Thank you so very much. If you, I mean, we are having a very engaged session, and we have a number of viewers and a few questions from the viewers as well. Before I, of course, mention them, I have a few last questions for you, which is, on a related note, we see that multi-party arbitration often raise problems in relation to the constitution of the arbitral tribunal. For example, in seminal cases, it had been decided that the right to appoint an arbitrator is a sacrosanct right in the international arbitration and remains instrumental in multi-party arbitration. My question to you is that, considering these difficulties in regards to multi-party arbitration, we have talked about a number of solutions. We have talked about a number of problems. We have talked about a number of issues such as delays or costs. Do you think rather umbrella rules to some extent in terms of, at least in terms of multi-party construction dispute, from a renowned authority or in collaboration with a number of authorities? I'm certainly not going to name them. Do you think sort of an umbrella rules in terms of this particular multi-party construction arbitrational dispute will be of some benefit to avoid these difficulties, including the last one that I've just mentioned?
I mean, apparent. So the challenge with multi-party, multi-contract type disputes is basically you require consent. That is the challenge. You require the consent of the parties. It's part of the foundational underlying nature of the arbitration process itself. The parties must give their consent in order to have in order to have an arbitration. When there is no such consent, then it becomes difficult. So let's interrogate your question a bit. If you have a scenario where the arbitration clause itself does not envisage a multi-party arbitration, because the arbitration clause itself does not envisage it, and then you have a scenario where the arbitration rules itself then envisages that the tribunal would then have the power to force a multi-party arbitration amongst between the parties, then that's potentially an issue. Of course, you would say that the parties have chosen the arbitration rules, and once the parties have chosen the arbitration rules, effectively they are entitled, they are bound by the rules which they have chosen to guide the arbitration process. Effectively, the rules as they currently stand is the rules themselves in most cases recognizes the full of party autonomy itself, and that's why oftentimes the rules then say that the parties need to give their consent in order to have such multi-party arbitration process. So this is very important, especially because you also find that you are not only talking about a multi-party situation, but you are talking about a multi-contract situation itself. So you have using the employer and the main contractor type scenario, and the main contractor and subcontractor type scenario. The subcontractor is not privy to the arbitration agreement between the main contractor and the employer. So even though as between the contract between the main contractor and the employer, they basically recognize that that rule should govern the arbitration process itself. But in the dispute between the dispute between the main contractor and the subcontractor who is being sought, the subcontractor in this particular scenario who is being sought to be brought into that reference itself, it then becomes challenging effectively. So where you have arbitration rules effectively So one thing that could happen is that the rules, for instance, could say that could give the appointing authority the 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 discretion effectively to be able to appoint um, a similar tribunal. So once they recognize that these disputes are related disputes, it may then appoint a the same tribunal to be able to determine the related disputes. So that could be one way to deal with the issue and to be able to avoid some of the problems. That doesn't seem to me now to be very clear from the ICC rules and the LCI rules, which we've looked at. Most of those rules effectively simply say that where you have this type of scenario, then consent is required. The LCI seem to follow a similar type of route. But one situation would be perhaps to give some level of discretion to the appointing authority where you have a related reference. Then in such situation, potentially the same tribunal constituted for the first reference may then be constituted for the purposes of the related reference as well.
Thank you. Thank you very much. We're almost at the end. I just have a few last questions before I acknowledge the questions or the presence of the audience. As we have thoroughly discussed throughout the session, that consent in this sort of scenarios is not easily ascertained, and it is generally difficult to have multi-party arbitration. In such cases, we often see that the parties opt for appointing the same arbitral tribunal in the related proceedings. How appropriate or how beneficial do you think that is?
I'm sorry, please, could you take the question again? I didn't hear
Oh,
that
yes.
clearly.
Yes. So as we have thoroughly discussed, that consent is not easily ascertained and generally difficult to have multi-party arbitration. And in such cases, we often see that parties opt for appointing the same arbitral tribunal in the related proceedings. How beneficial do you think that is in circumstances where consent is not ascertained? Having the same arbitral tribunal in the related proceedings, separate related proceedings.
Yes, which is, I mean, similar to the point which I just made, which
Yes,
is
yes,
you have once you have a common tribunal being appointed for both references, then that effectively deals with the problem of the risk of conflicting decisions. Because in such scenario, apparently, because the tribunal is obviously aware of proceedings happening in the related reference, then the likelihood of having conflicted decisions emanating from both references is extremely limited. So that clearly is a very good approach.
thank you. Thank you so very much, Mr. Martins. We are almost at the end of our sessions, and I have certainly asked you way too many questions than I anticipated. Certainly, I did not want to let this chance of getting to know all these important things from you. We have had messages. We have had messages and participation from Mr. Olalade, Mr. Peter Okapapu, Mr. Onaidim, and we have had participation from Mr. Alao, and we have Ms. Sadia Hussain, Mr. Olalade again, and everyone else joining in as well. Mr. Martins, thank you so very much. I think we have actually considered everything, and I have asked you questions even outside the realm of the initial discussion and the discussion for today. I would like to tell you that in terms of construction and in terms of construction related arbitration in Bangladesh as well, our real estate laws, particularly the amendment that came in the last decade through a new specific act, made arbitration very much relevant for the construction agreement of this sort and everything. This will be my last question to you before I conclude this session for today, which is for example, for less developed jurisdictions where the major contract in a construction agreement is between the employer and the contractor, and the subcontractors are usually numerous, and a party certainly having lesser footing than the other two, where in most cases there is oral contract or work order or not a precise contract between the contractor and the subcontractor. If you would kindly advise that for those circumstances, for those scenarios, uh, how do we amend or how do we tailor or customize the arbitration process?
So where you have a scenario um,
Let
where
me
the
help you with the background a little bit. For example, in Bangladesh, what happens is that the parties and the employer and the contractor will have a very decent contract and everything, but often it seems that other subcontractors are a party of a lesser footing, and often the contract between the contractor and the subcontractor is orally or on the basis of understanding or trade or customs. So there is a very lack of written document or a possibility for the presence of a clear arbitration clause between the contractor and the subcontractor. This I'm talking about the lesser developed jurisdiction and the lesser developed or the developing countries, that is. In those cases, if we were to consider arbitration of this sort, what would be your advice to tailor made the arbitration process so that we can bring everyone else and achieve the intended purpose?
I mean, I think that's a very good question. The challenge here is, I mean, it obviously depends on it depends on the applicable law. In most jurisdictions, and the arbitration laws in most jurisdictions usually require that arbitration be made in writing. And typically, where you have a scenario where some of the relationship in question are not regulated by a written or formalized contract with a written arbitration agreement, then that could then become potentially challenging where you are looking to have a multi-party arbitration reference. So apparently, like I said, it depends on the law. But one practical solution to that would be, for instance, to see if, for instance, it is possible for all the parties to enter into an ad hoc arbitration agreement where all the parties agree for the purposes of um, for the purposes of the arbitration itself. Again, another scenario, and this of course could be used in limited instances, depending on the nature and the type of the dispute. If the dispute is such that even though it is a subcontractor claim against the main contractor, which of course the main contractor has a right to seek indemnification against the employer. One way to go around it is for is for the main contractor to pursue that subcontractor claim directly against the employer, with the subcontractor providing all the necessary assistance in terms of documentation, substantiations, and all whatnot, to support the main contractor's claims against the employer, on the understanding that on the understanding that you know on the understanding that the whatever the subcontractor is entitled will be due to the subcontractor, depending on how the dispute go between the main contractor and the employer. Of course, these are all very loose scenario because of the way because of the way the contractual arrangement is. So potentially, even though it may not be possible to have a, even though it may not be possible to have a multi-party arbitration arrangement, but because the subcontractor under the law, under the governing law in question, has a right of recovery against the main contractor. Maybe not under arbitration because you do not have a formalized arbitration agreement, but in any event, under the laws, has a right of recovery against the main contractor. That may potentially be an incentive for the main contractor to pursue arbitration against the employer in order to recover the subcontractor's claims from the employer, knowing full well it's in any event liable to the subcontractor.
Thank you so very much, Mr. Martins. I think we're almost at the end of our session, and I think the practicability and the applicability of all your answers was so great that I think beyond the webinar, these could be actually implemented as valid and crucial legal advice for arbitrators around the world. And certainly the questions that I've asked in regards to our jurisdiction is will be your answers will be of immense benefit for the law, even for the lawyers in terms of drafting as well. So thank you so very much. This has been a very difficult and a very crucial and a very important topic in modern day capitalism and in the modern day legal scenario. As thank you so much for expressing it in such an easy manner. I'm certain our viewers have had a very nice time listening to all these amazing and important and crucial aspects of construction arbitration. Thank you for entertaining all my questions. I actually could not resist. We certainly wish to have you back with us in any of our other webinar series. Dear viewers, thank you very much for joining with us. I hope you have had a great time. You have enjoyed it as much as I did. Thank you very much for joining in. Please stay safe under the circumstances. Stay safe. Watch, keep your eye on CIADR, its official Facebook page. And this is your host and your moderator for today, Barrister Faisal Mahmood Honorable, signing off. Thank you very much.
Thank you.
Thank you, Mr. Martin.